afternoon. I'm Mark Fry. I'm the new chair of the Bath Community Fund Board, and we're glad to have you here for this event. Our Bath Community Fund is, you can find information up here about it, but we're heading into our 10th year, and so it's amazing. And the grant period has just ended, and we're getting ready for the grant committee to meet to divvy out $50,000 in grants for the coming year. So that's really a great thing. And you'll be hearing more about the fund as we move into 2024 and our 10th anniversary time. We got some big things planned. But tonight we have another big thing planned, and I'm going to ask Jody Constance, one of our founders and board members, to come and say a little bit about our program this evening.
Thank you, Mark.
And if you need to help yourself with refreshments, right?
Anyway, doesn't matter, okay? Doesn't make any difference. Good evening. Hi, everybody. Hi. Thank you so much for being here. This is Judge Elinore Marsh. She is a friend and pretty amazing lady. And I'm going to tell you a little bit about her before we get started, just to give you some background. With us also is Steve Elliot, who is your chief magistrate. And the two of them are going to present a program that I think is really important. It's about planning for the future, and the future when maybe you're not here, and what to do with the assets that you've accumulated and the treasures you've accumulated. But I want to first tell you about this lady right here to my left. Okay, so and I'm going to get away from her because I'm going to go lunch.
I'm going to step away too, just in case.
Now, you have to understand, the judge is a judge because she saw a problem. Too many people in jail, mostly for drug and alcohol offenses, and too many judges who wanted to keep them in jail. So she ran for judge because she believed in using treatment versus incarceration. She won election to Akron Municipal Court in 1991.
I think everybody here was alive then, but I do get the days and somebody goes 1991. I think that.
I was in high school then. See, that's why I stepped away.
Yeah. She's been reelected in every election in which she has run ever since then. Now, she is in the very best sense an activist judge, and I use that in a wonderfully specific way, okay? When she saw a problem, she solved that problem, and she worked to solve that problem, and that's being, in my estimation, an activist judge. Now, some of the things that she has done, when she was established the first municipal drug court in Ohio in 1995, at a time when there were very few drug courts in the entire country. 5 years later, she created the mental health court, again, the first in Ohio, because, and this is her quote, mentally ill people aren't going to get better just because you're threatening them with jail. She was elected to the Summit County Common Pleas Court in 2004, and Judge Stormer then created the county's first reentry court. And again, it became a model for the state, and that was a court that would help felons ease their transition back into society and to become law-abiding citizens after they were released from prison. She was elected Summit County's probate court judge in 2012. She continued her innovations in that court, creating a number of programs that were designed to serve the needs of the most vulnerable people that came to her court, particularly vulnerable indigent wards of the court. In January of 2016, Judge Stormer began New Day Court, the first of its kind again in Ohio, providing a path to recovery for those suffering from severe mental illnesses. It was another specialty court that was created by her, and it's become a national model of best practices. Last year, Judge Stormer was awarded the 2022 Thomas J. Moyer Award for Judicial Excellence by the Ohio Bar Association, recognizing her innovations that have reshaped judicial practices throughout the state and the country. The award was also recognition of her, and I quote, integrity, fairness, open-mindedness, knowledge of the law, professionalism, ethics, creativity, sound judgment, courage, and decisiveness. The graduate of Davidson College and the University of Akron School of Law, she's an apple who doesn't fall far from the tree because her folks were extraordinary people. Her mom in particular, who was a friend. Anyway, she is a wife, a mother, a grandmother of both two-legged and four-legged grandbabies, and a very smart, really nice lady and friend. Okay, joining Judge Stormer is Steve Elliott, who is her chief magistrate. Now, Steve served in the CIA before he went into the law. He practiced probate law and civil litigation, worked in parole, assisting felons in their return to society. In 2018, Steve joined the court as a part-time magistrate, court investigator, assumed the role of a full-time magistrate, and then became chief magistrate in January of this year. Like he said, he's the one who gets most of the questions directed to him. So he is, according to the judge, a passionate advocate for seniors, those living with serious mental illnesses, and the community's most vulnerable adults. He's a Canton native, a graduate of Bowling Green State University and the University School of Law, married and the father of 3. So I will turn the floor over to these two.
Thank you, sir. We're here from probate court. I'm enjoying being in probate court for the last 11 years. And we get an opportunity to come out and meet with people who really, you're here for free legal advice, right? You're not, it's okay. We know that's why you're here, and we're here to give it to you. So how many people have been to probate court? How many people got married in the state of Ohio in Summit County? You all went to probate court because that's where you get the marriage license. So we do marriage license adoptions. We have jurisdiction over more than 200 different kinds of things, guardianships, conservatorships, but we're here to talk about the bulk of our practice, which involves estate. Steve is an expert on trusts. And so some of you may have questions about trusts, and we're going to have him available to answer some of that. But first, we're going to talk about the things you should do. Jody says plan for the future. We say plan for the very end of your life and then beyond. So if you've got your yellow sheet, let's talk about your yellow sheet. So this was a form that was designed because in dealing with my own parents, so I'm going to use as examples throughout the evening, they did not know where their stuff was. So when we did this, and I brought the yellow sheet home after they see me give a number of presentations, they go, we probably ought to do that. It took us 3 days. My mom had stuff, my dad had stuff, they had different file drawers, they had computers. Nobody knew their passwords. I knew their primary care physicians. I had no idea who their specialists were. I did not know where their credit cards were located. So what this is a guideline for you. And I strongly encourage you to do it because when they both died, it was all here. We collected it. We had it on the yellow sheet. I knew who I was supposed to call. I knew what I was supposed to do. And it was, it's a painful process, but this does relieve your heirs and friends and family from having to go rifling through every drawer looking to see, do you have a will? Where is the will? Where, who is responsible if there's a mortgage on the house? Where is your checking account? Do you have investment accounts? If so, who has control of those investment accounts? Are there people who are beneficiaries of those accounts? So those are all the things you have to wrap around when somebody dies, which is not what you really want to think about. You want to think about, I am in grief. And this encourages you to move quickly through the business part of someone dying without causing extraneous and external harm to them in that moment while they're going through all the letters that your parents received, and then you find the will, which you can do. You want to do those letters when you have a moment to really reflect on those letters. So I strongly urge all of you to do this. There is no advantage to it being yellow. We just made it yellow so you could tell your family, if something happens, find the yellow sheet. It can be any color. We have lots. You can take them, but you're also free to make copies of this in any color that you choose. So the one thing I want to point out particularly is electronic and media checklist. So when I was first practicing law, we would tell the families, just go check the mailbox regularly. You'll find out where the bank statements are, the mortgage, everything will come through the mail. Well, that does not happen anymore. So this is a way for you to tell passwords, and don't do what my dad did, which was about 12 days before he died. He decided he wanted to make double secret passwords. Okay. Which we found some of them, but we didn't, even though he knew about the yellow sheet. So he did, he changed a bunch of passwords. So if you're going to change it, just print out another yellow sheet or amend the document so that it's there, because that's where really we keep all of our information about ourselves these days. And if you have auto pay or things like that, it's going to show up that's where you need to go. And the other thing I'm going to say is you get ready to do this is you also want to think about independent credit cards. So if you are married or partnered with someone and you have the person who is the primary breadwinner, let's say, or the primary investment person, all the credit cards may be in that one person's name. When that person dies, once you start notifying people, they cut off the credit card completely. Happened to my mother. So she had one credit card with an investment company and another credit card for gas, and they were both in my dad's name. So she had no credit. The moment that they found out that he died, they cut the credit card. Now, we were able to resume that, but it's not something I ever would have thought of. So if you don't have a credit card in your name, please get one. It can be anything, a gas card, whatever it is that you can use to conduct your business so you get everything else in order. So I did not know that until that happened with my mom, so I pass it on to you to help you avoid that. So let's take a look at some of these other documents. We've given you a beautiful 2023 summary of what we do in the courthouse. The definitions, but I want to talk about some of the things that are in here which have to do with your plans for the future and beyond. So how many people here have a will?
The record.
Yeah, that's really, everybody has a will. How many of you have power of attorney? Almost everybody. How many of you have a healthcare power of attorney? Almost the same. Y'all all have lawyers, don't you? Lawyers.
We can just leave you.
Yeah. And how many of you have advanced directives if you cannot speak for yourself? Not quite as many. Well, all right, let's talk about that then. So just to point out a couple of things, the healthcare power of attorney just gives someone the right to make a decision if you can't speak. It ends when you become terminally ill. And it's defined in certain ways. I will tell you that I defined that in my own documents to say it includes dementia. Physicians do not include dementia as a terminal illness. They know you're going to die of something else. It can be pneumonia, it can be COVID, it can be whatever, but they don't consider those things, the dementia to be terminal illness, which is what I think most of us are afraid of. That our family's going to be forced to keep us alive when we don't know who they are. And we want to avoid having, being kept alive for an extended period of time. And I won't bore you with the horrible stories, but I have horrible stories about families who said, what can we do? They're forcing food down him. He's in a room, he's moaning in pain. They won't give him medicine to, ease the psychosis that he's experiencing because he's dehydrated because he won't drink. So if you don't want that to happen, I encourage you, in addition to having your advanced directives, which say, this is what I want if I am terminally ill and cannot speak for myself, to fill out this form, which is what if I had dementia. Now, to be fair, this document is not recognized by the state of Ohio, but it is recognized in your Summit County probate court. So it means that if you tell us, this is what I want, and this is what I don't want, we consider this to be a contract for you in your favor. So if I had mild dementia, I'd be willing to put up with this. If I had moderate, if I had severe. So mine says, if it's severe dementia and I do not know my family, then please just stop doing things to me. I don't want to be treated for pneumonia. Yes, if I break my arm, please set it, because that would just be painful. But if I get a disease or something else happens, don't do a bunch of elaborate testing on me. Just please let me be. Keep me comfortable and put me into palliative care. So this is a document that if you want to fill it out and you feel comfortable with it, you want to add that to your documents list and keep all these together. The advanced directive, some people don't understand what that means. It is a contract with whoever signs it that says they're going to follow your wishes, and we will follow your wishes no matter what your family says if you fill this out. So we had a story a couple of years ago when there were 6 kids. Mom was a nurse. She was terminally ill. She had told everybody, if I fall over in the kitchen, please do not call 911, because if you call 911, they have to resuscitate, even if you have a do not resuscitate order. You call them, they will do their job, they will save your life, and they will take you to the hospital. And the 6 kids took turns staying with mom, and the one night when she fell and was unconscious, the daughter, who was the nurse, called 911. Took her to the hospital. She died in the hospital after multiple tests, all kinds of invasive procedures. 6 weeks later in hospital. The 5 other kids no longer talked to that woman because, it's just the family should understand what your wishes are. This is telling, and nobody brought the advanced directive in because the hospital would have had to say, we're going to stop. So I just recently had a case where a brother and a sister were arguing about what was gonna happen with their dad. So this is what happens if you don't get agreement with your family, if you don't tell them what's happening, I make the decision. This man was dying, he was being kept alive on machines. He would die in 6 months, but it would be painful and long, and there was no value, just like he didn't know who anybody was, he could barely wake up, etc. So my order was that because the son was in favor of it, all the doctors were in favor of it, that he be allowed to die. So do you really want me to make that choice? Wouldn't you prefer to make that choice? So that's what advanced directives do. They tell us and your doctors and caregivers what you want. So if you haven't done it, or you really need to think about doing it. If you haven't looked at these documents in 5 years, I encourage you to go back and look at all of them again. Has anything changed with your will? Has anything changed with the people you want to be in charge of what's happening to you? Has anything happened in your life that makes you want to revisit any of the terms and conditions that you've laid out in that document? And we always say if something big happens in your life, if a child marries, a grandchild, moves to Sweden and says, I don't want to see you anymore. Those are things, that's what we do. We are involved with families, and families don't always agree. That my favorite joke is, what's the definition of a dysfunctional family? Family with more than one person in it. So I'm not making a remark about your families. I'm just saying it can happen. It can happen. So you want to revisit those documents every couple of years and make sure that they still specify what it is that you want. So how many people here tonight came because you wanted to avoid probate? Oh, only just 4 or 5 of you will admit to it. Come on, you saw all those ads a long time ago. Avoid probate. This is the way to avoid probate. You pay me $3,000. I'm going to tell you what to do. So we're going to tell you for free. If you want to avoid probate, you have life insurance with a specified beneficiary that passes outside of probate. You can have all of your accounts, savings, investment, checking, can all be transferred on death accounts. So they can be payable on death to a person. We often get the question, well, should I put my daughter on now? You can, but she becomes a co-owner of your bank account, which means she can take the money out if she wants to. Does that happen? Not very often, but when it does, it's always bad. I mean, just to put it bluntly. So you have PODs or TODs, they're called, depending upon your bank. Investment accounts, if you have them, can be named a beneficiary. Anytime you're naming a beneficiary, it's going to pass outside of probate. So how many people have an investment account of any type? Almost everybody here, which is kind of what I expected would be the answer. How many of you have Roth IRAs? Okay, Roth IRAs will transfer to your intended beneficiary in whole, and they do not have a requirement as to when your heirs need to take the money out. Old-fashioned IRAs, how many have those? A couple of you. If you have an old-fashioned IRA, the rules just changed. So if the person who inherits first is the spouse can take the money out over a lifetime. There are taxable events that occur every time the money comes out, and after a certain age, there are required minimum distributions. If, however, your spouse dies and you die and you have children and you're leaving the IRA to children, right now, as of April, they have 10 years to take the money out unless they are a minor. And then there's different rules, or in some cases, if they're special needs people. So if you think about that, if you're trying to leave money to your kids from a regular IRA, they need to understand that they will have to pay tax on that, and they have to take it all out within 10 years. So if in their 40s or 50s, in their highest earning years, that may not be a great gift to them because it bumps them up into taxes. They're not going to really get, if you leave them 100, they might get 60. Just something to think about. Because if you're over the age of 73, if you have a required minimum distribution, well, you can leave that whole thing to the Bath Community Foundation. And there are no tax consequences. Or any charity of your choice can receive up to $100,000 of your RMD, and there are no tax consequences to you. Your heirs over the age of 73 can also do that. So any part of your charitable inclination, you can live that, and your heirs, you can tell them, hey, you've got this option, think about this. You can also put into any of your accounts, the desire to put money into the Bath Community Foundation. You can do it now, you can do it later, you can definitely do it after your death. If you leave a will, which we encourage everyone to have a will, because sometimes it just turns out you need one. There are decisions that have to be made, and sometimes there's unclaimed funds, or there's an account that you forgot about that, you didn't put on a POD, nobody knows what to do with it, you have to open an estate. So we encourage you to have a will just in case you have to do that. And so sometimes you have to open tax returns for trusts that you're inheriting. There are just a lot of reasons to have a trust, and Steve is really going to be the expert on the trusts, because I only interpret them after they're drawn up, and he knows how to write them and the different issues that might arise with that. So anything that you want to leave TOD, we've talked about the accounts. You can also do this with your car or your house or any real estate that you own. So you can put your 7 kids on the transfer on death deed to your house. Who thinks that might be a good idea? That is not a good idea. And here's why. It goes to the 7 kids, which we've actually had this case. They're all married. So now there's 14 people who have to agree on everything that happens to the house, because the spouse has a dower interest. So I inherit, my husband has a dower interest in whatever property I inherit, if it's real estate, and can then say, I always hated your brother, so whatever is happening, I'm not going to go along with it. If you are trying to leave someone the house itself because they want to live in the house, then you can leave that person the house and, affect your distributions in other areas. If you have all 7 and they decide they want to sell the house and split the proceeds, all 7 have to agree on pricing, the real estate agent, the time plan, etc. If you have a will, you can just let the house go into the will, and we will make them sell the house, and we will make sure that they divide the proceeds appropriately. So there are reasons to have a will, potentially, if you want to leave real estate to more than one child. If you're trying to leave the house, figure out who you want to have the house. If you're trying to leave them the money that the house represents, a will is a better way to do that, because it avoids all of that conflict. And believe me, it's usually not the children, it's the spouses. And I'm not, I'm an in-law to other people, Steve's an in-law to other people. Somehow there's always one who's whispering, well, you did so much more for her than he did. Why is this fair? So that happens anyway. We actually had a case where a man came in, he was contesting everything that was happening in the state because he wanted the axe, axe, in the basement. So our magistrate has a hearing and to determine why he wants this axe. Why is he holding everything up for this one item? Here's the answer. Well, that was the axe I used to break the door down when Mom would let me in. It's very meaningful to me. That's what we do. You can't believe what people fight over. At any rate, no one could find the axe, probably because Mom had burned it after trying to break the door down. But I mean, we do have hearings on, it's like they're going to fight over the dust bunnies under the bed sometimes. So Steve's going to talk to you about trust. I'm going to say one thing before he does that, which is this. You don't have to pick your oldest son or your oldest child to be the trustee. We see a lot of those cases. Sometimes trustees get confused about their duties, and Steve's going to talk about that, and think that it's like their money. And they can give it to their sister or their brother, when they feel like it. In the meantime, they're going to pay for their kid to go to school, buy a car, upgrade the house, etc. So Steve's going to talk to you about the benefits and dangers of trust. How many of you have trust, by the way? Quite a few. Half. Okay. Yeah.
So I'm Steve Elliot. I'm Chief Magistrate of the Summit County Probate Court. Does anybody know what a magistrate is? One person. That's usually the response I get. Everybody knows the judge, but nobody knows magistrate. So when I started working in the court about 5 years ago, just a quick funny story, and you'll never forget what a magistrate is after this. I went home to my kids and said, hey, I'm actually changing jobs. I'm going to be magistrate, Summit County Probate Court with Judge Stormer. And they were like you. They said, do you know what a magistrate is? And their looks look just like yours. And so I said, well, Judge Stormer is the elected judge, so she's the boss, but she has magistrates that help her. So I wear a robe. I have my own caseload. I sit up in front of the courtroom. I make decisions. I write decisions. I do everything like the judge, but I work for her. And they said, so you're a mini judge. So magistrates are mini judges. And to take it a step further, 2 years later, when my kids were teenagers, they got me for Christmas a little mini gavel. Since I'm a mini judge, so now you will never forget what a magistrate is. So something I just wanted to add on to Judge Stormer's transfer on death conversation. Everybody, who here has transfer on death and or beneficiaries named on accounts? And Judge touched on this, and I just want to mention it again. When you pull those wills out to take a look at who's named in the will and who's on your healthcare power of attorney, pull those accounts out and see who's named as the transfer on death beneficiary. Those transfer on death beneficiaries, those documents, the IRAs, 401ks, 403bs, beneficiaries on those documents basically override what's in your will. So what do I mean by that? If I have a will that says everything's going to my 3 kids equally, but I have 3 different investment accounts and I have their name, like I have my son's name on one, my other son on another, and my daughter's name on another. The names on those transfer on death accounts trump what's in the will. So if I have that account that I gave to my mom, because I did it before I was married, so I have that investment account and I forget about it. When I die, even though my will says everything goes to my 3 kids, that account says it goes to my mom, so it goes to my mom. So make sure those transfer on death beneficiaries are updated, just like your wills are updated, so that we make sure that that's what happens with it. And I can use those transfer on death beneficiary designations to go into trust. One of the beneficiaries you can name on those accounts and life insurance and all of those things is your trust. Does anybody have transfer on death beneficiaries named to a trust? So they really did all go to attorneys.
And good attorneys,
Exactly. So that those assets then will transfer right into that trust when you pass away. And then it goes into the trust, and then the trust controls who the money goes to. So what is a trust? A trust is a document we draft now, and when we draft it, it kind of establishes its own identity. It's like a person. So that we draft that trust, it becomes its own entity, and then what do? We transfer assets to it, and that trust holds those assets for us. There are so many different kinds of trusts, I can't even name them all. There are a lot of them. There's a revocable trust or living trust, revocable living trust, all kind of the same. We have different types of tax shelter trusts. We have different types of trust to avoid liability. One of the biggest things with trust is it revocable or irrevocable? If you have an irrevocable trust, we establish that trust, we put the terms into it, we say this is what we want to have happen with that property. And once we put the property in that trust, we can't change it. So you can't change it, and it lasts forever because you can't revoke it. There are some instances where we can revoke it as the probate court, but that irrevocable trust is there and we can't make changes to it. Why would we want an irrevocable trust? Mostly for tax benefits. In order to avoid, has everybody heard of the death tax or estate taxes? Does anybody know how much you can pass tax-free this year if you pass away?
12 million plus.
Yep, $12.92 million. And if you're married, double it, because you can tack on your spouse's interest in it. So a lot of people drafted irrevocable trust back in the day when the amount was, $500,000, and it's an irrevocable trust. So just something to think about as you're doing these things. So if you do have over the $12.92 million, her name is Elinore, Marsh, Elliot. Feel free to pencil us in there. So just something to think about with irrevocable trust. However, they can be very effective tools if you are in the situation where you need to avoid those death taxes. One of the
that's only at the federal level.
correct.
There is no tax in Ohio anymore as of 2012. So there are no death taxes, which is really just a transfer tax. But they wiped them out in 2012.
And those were a lot lower. It was $338,000. So that number was a lot lower. And that was the biggest reason why people used irrevocable trust, was to avoid the state death tax. One of the things that I know we want to talk about here is a charitable remainder trust. So that is a trust that you can establish now. You can put assets into it, and then you put plans in place to spend the income from that trust. So I can form that charitable remainder trust, transfer assets into it. And then as the income comes in, I can make Judge Stormer a beneficiary, and a certain amount of money can come out to her, tax-free to the trust, so that distribution's being made. The biggest advantage to that charitable remainder trust is when I would pass away, then the money that's in that trust passes to the charity of my choice. Well, of the IRS's and mine's choice, because the charity has to be recognized by the IRS as an actual charitable foundation or charitable organization. So the advantage to that, again, is if you are looking for that advanced tax planning, money that you would put into that charitable remainder trust then would pass tax-free outside of what your normal estate would be, or your normal estate tax would be. So it kind of carves out whatever asset it is you put in there from your estate tax. So if you're in that level of assets that you would have to worry about the federal tax, that charitable remainder trust, whatever you put into it is carved out of. So it could take you from having to pay tax, say if you had $16 million and you put 4 million in there, that would bump you down below where you wouldn't have to pay a federal estate tax, because that $4 million, once you give it to the trust, is carved out of your estate, and then that would pass to the charity tax-free, and also protect the assets, your $12 million that you could give to your family. And so that's probably the biggest type of trust we'd want to talk about here.
Well, I don't know. We also have special needs trusts. Does anyone have you heard of those? Okay, so that's for someone in the family who is receiving government benefits, and you want to protect their government benefits by providing things like, for example, the one that always comes up is depends. You can't use Medicaid, you can't use Medicare. This allows you to keep your benefits and to buy things that you might need to live in your house. Changing, adaptable handles so people can use, putting in a ramp, things like that. And people use them we see it primarily for people who are developmentally disabled, or a child who's looking after an older adult who is receiving government benefits. So it keeps them still able to access that care, which is very important. And you're not getting 12 million. If you have $12 million, then they should somebody will manage it for them and make sure they have everything that they need. The other one is a spendthrift trust, which is if you have someone you love who is not really responsible and you want to make sure that they can be taken care of, you can do what's called a spendthrift trust, so that Johnny, if he falls off the wagon again, can't access the money, it's controlled. They have to give him, I think, a minimum of $5,000 a year, and that's it. It is also not touchable by creditors. So if Johnny gets sued, the money is still safe and still used for his life, his benefits as time goes on. So really what trusts do during your lifetime, it allows you access to your money if it's revocable or you are the beneficiary of an irrevocable trust. But it really is you talking from the grave most of the time and saying, this is what I want and this is how I want it dispersed. I do think you should talk to your financial advisor before you put IRAs, regular old-fashioned IRAs, into trusts. There are so many other ways you can use that money to benefit people differently than to put it into a trust. Trusts are taxable. There is a tax return that has to be filed on the trust after the death of the people who are the settlers or the people who set the trust up. So you have to remember that. It depends on how much income there is. Somehow the government takes a lot of it. I don't know exactly how that happens, but they do. They're always there. So that's kind of a basic introduction to trust. If you all have them, the big thing I want you to remember is you have to talk to the people you've designated as your trustee. We deal with a lot of cases where the trustee does not know what the job is. And it is complicated. It requires, by state law, periodic reporting to the other beneficiaries, which nobody seems to know. And the beneficiaries begin to suspect, even perhaps wrongly, that Steve has taken all the money because he hasn't sent out any reports. They can just give you access to the accounts where they can look at them. That's confounding enough because they can look anytime they want. To do periodic reports, you are required to give them copies of the trust, which again, people don't seem to want to do that, usually to siblings, which is what I do. I deal with a lot of family members, children who are fighting with each other about how the trust has been administered. If you have a trust where the bank is the trustee, does anyone have a bank as a trustee? good.
Good.
Because it is very hard to get the money out of that bank. It really is, and I can't explain it. But a lot of times your trust will require that upon disbursement of the trust funds, they go into mini trusts. So 4 kids, 4 separate trusts. This was the case with my parents' trust, which was done in the 90s. It was a tax to avoid tax trust. And I'm a judge. My sister runs the largest psychiatric hospital in Texas. My brothers are both real estate developers who have way more money than anybody who works for the government like me. And we had to go, they wanted to put it into a trust for us. And we're all in our 60s. So really, if you can control the trust, if it's a revocable trust and you can change things, you may want to go back and just make sure that there's nothing in there. Now that your children may be older, you may have said when they're young, I want to go into a trust for them. If it says that now, you may want to look at that and say, does this really make sense today? You know, do our children need someone watching their money, or have they shown us that they're able to take care of it themselves? And if it's revocable, then you can change it so the money goes to them outright. If you want to leave money to grandchildren, you can stagger it. They get so much when they're 18, 21, 25, 30, 35. But you don't really want it hanging on forever. And we've seen that, you know, people in their 60s. I just recently had a case, he's 67, and he wants control of the trust. In fact, he probably shouldn't have control of the trust, but it's millions of dollars. He is well cared for. He has a personal chef. He has enough money to have people from the Cleveland Orchestra come into his house on Thursdays and play for him while he enjoys his dinner from his chef. He has a beautiful life, but he somehow thinks he needs to control the money. And there was a lot of disagreement about that. In his particular case, it is better that he does not have control of money. He would lose all that within 2 years, probably. So it should be personalized. What you're trying to do as your family gets older and you know the kids and the grandkids, you know, you can tailor your trust during your lifetime. You could also tailor it from the grave. We have one trust that was established in the late 1800s to benefit a cemetery that no longer exists. We are trying to get them to spend some of the money on the Glendale Cemetery because it's kind of a comparable cemetery, but every single time we have to go through a series of hoops that are required by law to get the money to the Glendale Cemetery. So one of the things that we do, no matter who you leave the money to, if that thing doesn't exist anymore, they can come to court. It's called cypre, and we can then say, well, if they wanted to leave it to this animal shelter in Stowe, but that doesn't exist anymore. So we feel that the comparable entity would be the Humane Society of Summit County. We had one guy who left all his money to a, can't remember the name of the Revolutionary War, those guns, you know, they had the guns, you had to load them, muzzle loaders. There was a muzzle loading club in Pennsylvania. And he left all the money to them. By the time he died, they were gone. But we did find a muzzle loading club in Indiana. So we try to tailor it exactly to what you have told us you want. That's why we say revisit it. Does the church still exist? A lot of churches have been merged and gone into other places. Some of them have been sold. You know, that's happened here according to the look on your face. So if you want to leave money to, you know, St. Wenceslas and they don't exist anymore, we will try and find a church that sort of mirrors the St. Wenceslas motto, or, you know, the same kind of services that they were providing. So that's kind of an intro to what we do. We've got a lot of information here about the other things we do if you're interested. And I just want to mention one thing, which is there is a volunteer guardian program in Summit County. We started that when I got there. There are some people who just don't have anybody anymore. Some of them deserve it. Many of them don't. And we're always looking for people who have a heart to help someone who doesn't have anyone. There's training, you know, which we will match you with someone according to your preferences. If they're already placed in a nursing home, we'll try and find a nursing home near where you live. My husband has done it. He had 3. He now has 1, because 2 have died. And he really has grieved these people. He got to know them. He would visit them. So if it's anything you might be interested in, we try to promote them. Here are the brochures on it.
It's a good program. I'm one of your guardians.
Are you? Well,
Yeah.
I'm so glad I know that now.
It's a great program. It really is.
Well, should we leave some just in case? And you know, really, it takes as much time as you want to put into it. You have to meet with the care conference team once a quarter. Most of our guardians develop relationships with the people and visit a lot more than that. My husband goes once a month to visit the last ward, and she's seriously mentally ill. She loves to wear jewelry. We buy costume jewelry for her and she's very happy. She thinks that my husband is George Washington's brother. Which is just delightful.
Something that just sparked in my memory that I should have mentioned earlier when she touched on it too with wills. If we're gonna name somebody as our attorney, in fact, on our powers of attorney or trustee of our trust or executor of our will, then I'm sure if you have attorneys, I hope they told you this, please talk to them ahead of time and make sure they're willing to do it. Because sometimes you may name somebody and they go, whoa, wait a minute, I don't want to do that. Especially with trustee, if you have an ongoing trust that may last for a long time. Because as they're doing that, it can be a lot of work. They may be handling difficult beneficiaries. They have tax returns they have to deal with. There's a lot of work that goes into it. So make sure you talk to them ahead of time. And if you're trying to decide who to name, and Judge mentioned, you don't have to name your oldest son. Think about who it is that you're naming. So if you have 3 kids, one of them's an accountant, one's a teacher, and one's a doctor. Perhaps the accountant who's familiar with numbers and deals with that on a daily basis may be best for the trustee, and maybe one of the other ones.
Even if it's the littlest daughter.
Right, it doesn't matter who it is, but it's funny because I can't tell you the number of clients I met with over the 15 years in practice that just said, oh, my oldest son. That's who's gonna be it. Well, tell me about your oldest son. Well, he's been divorced twice and he's been foreclosed on 3 times. Okay, well, that's not who you want to be your executor. Look into it, think about what it is they do. They're managing that money. They're handling your money for you. That's what a trustee does. They make sure that what you put in that trust document happens. So you want to make sure that person can handle it. And ask them ahead of time.
And that's
So
the
they're not
same with your
surprised.
powers of attorney, particularly your healthcare power of attorney. They should do what you want. It shouldn't be a struggle for them to know what you want. So we actually have some videos on our website called From the Conversation Project and the 5 Wishes program and a letter to my doctor, all ways that you can express what it is that you want, what's important to you, and how you want to live your last day. So we don't want to ever think about that, but we all will, of course, have a last day. And just because you've done this does not mean you're going to die. I've had all these documents. I was in my 20s. I'm 67. So a good 50 years, it's been okay. I've still got my documents. But my mom was a nurse. And so she had a surgery that things didn't go quite the way she wanted. She had expressed everything that she wanted in her living will, her advance directive. She was very clear. They tried to put her on a ventilator. She was able to speak and said, no, no, no. And literally, no, 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 like a child. And they kept going, but, and she goes, I'm a nurse. I do not want to be on a ventilator. I'm telling you, I don't want to be on a ventilator. I am ready. So finally, they agreed that she was competent to make this decision, which was very clear to all of us, I think. And on the day that she died, she woke up in the morning and she said, okay, I think I'm ready to stop breathing today. And yeah, well, it was very interesting what happened. We were there, her children were there. She said, I'm done. She said, bring me the doctor to order the morphine. Nurse, right? So the doctor comes in looking very confused. She was about an hour later than my mother wanted her to be there. And she said, I want the morphine. I don't want to keep breathing. And she's got this confused look and she's looking at me and my mother goes, look at the patient. Look at that. And I said, this is what she wants. So she ordered the morphine. They gave her the morphine and then a very nice nurse came in to bathe her. And after he finished and she was very comfortable, I'm gonna get a little choked up. He said, is there anything else I can get for you? And she said, well, I'd really love a glass of white wine. And he said, I don't have any white wine, but I have more morphine. She goes, I'm ready. So he gave her the morphine. We came back in. I left. I will be frank, I couldn't bear it. I'm the child who's here. The other ones were in from out of town. And her last words were, I'm ready to meet my creator. Now, is that a good death? Yeah. I think that's a pretty good death. I miss her every day, but when I think about it, that's what I want. If that's what you want, you need to talk to your family about that because we weren't fussing. It's like, this is what she wants. She's told us repeatedly. So it's hard to do. But at the end, we were joyous for her. I mean, she was going to die soon anyway. This was on her terms, and we hope she was high as a kite. But she was obviously very spiritually intentional when she died. I mean, God love her. Wherever you are, Mom. So do you have any questions for us now about any of the things we talked about? I think you ended about 5:30, is that right, Jody? Oh, we'll stay longer if you want, but.
How easy is it to change the executor in the trust?
The trustee in the trust, you're
Yeah,
talking about the trust
yeah.
document, as long as it's a trust that you're able to amend.
Which is written into the document.
Which is written into
Should
the
be in the
document.
document,
So if it's a revocable trust or a living trust, usually those you can amend. You literally just have to draft a document that says, instead of Steve, I want Elinore. And then you sign it and have two witnesses sign it as well. It's
And
just
label
like
it a trust amendment.
trust amendment, not a codicil.
Yeah, we
A
just had
codicil
that
is a, we
case.
just had that. case, yeah. A codicil is amending your will.
Will.
A trust amendment amends the trust. So that,
Thank you for your website. It's fantastic. I send people there all the time, but I'm just curious, in what cases can someone contest a will? Because I've been subpoenaed to court twice. Both cases were ones that the people did not have the conversation with their kids. So that conversation is so important. But in what cases can people contest?
Anytime they
Anytime.
want to.
Okay, so a big reason to have the.
But that doesn't mean it's successful. I
Yeah.
mean, sometimes they say she changed her will, there were people, in her ear. Suddenly this neighbor appears and says, she wanted to leave everything to me and she wrote this thing out. Sometimes there's lack of capacity, same issues. So there's usually medical information that supports one side or another on that. And people change their mind, and you can amend your will seriously just by doing a writing with two people witnessing it who are not named. And you can also leave a list. So if you want, your daughter to get grandma's jewelry and your son to get the tools, you can put that there so they can't fuss about that either. And we recommend that you attach that to your will and also let them know. But sometimes people just don't want to talk to their kids about that stuff. So if you can always leave a letter saying, this is exactly what I want, and you can change it anytime. It's just a piece of paper. You can add or subtract to it. So you had a question in the back.
Yes, you were talking about credit cards when one spouse dies, the
Yeah.
credit card. Does that also apply to joint credit cards?
Yes.
Joint
Yes.
accounts? Joint
Yes,
accounts.
because there's always one person who is the primary signatory. So if you think back about when you got that credit card, you signed and perhaps your wife signed. If you're first, it's your credit card and she's the secondary. And the moment that they find out you've died, that's it. They close it because you're primary.
And what's your fix for that or your recommendation?
The spouse should get a credit card in his or her own name. So, it's, my husband went and got, my husband's from England, he's a United States citizen now, but he didn't have credit over here until after we were married, so he was secondary on mine until I learned about this, and I learned about it, actually before my mom. We just thought that it was all handled for them, because they'd been to this speech, they'd heard this. You just go have whoever it is apply for anything. If, they can go to any place they want to sell you a credit card right now, so get a 10% discount. So she or he can sign up for whatever the credit card is, at whatever that place is, and then they have credit in their own name. But you want a credit card that you can use other places, which most of them are now. I mean, even Dillard's, you can use any place, Macy's, you can use any place, so.
I have real quick, does anybody here have a safe deposit box?
Oh, that's a good one.
I want to bring this up because we've had a couple of cases recently that have made us add this to our presentation. If you have a safe deposit box, don't put your will in there unless somebody else has access to that box. Most often people think, well, my executor can get in there and get it. Well, the problem is the executor is named in your will, and if your will's inside the safe deposit box, we don't know who the executor is. So you have to come to the probate court and file an action to get access to that safe deposit box to just take the will out. So we've had two cases recently where a surviving spouse, it was two ladies. I think it might have even been the same day. The one lady came.
It was at the same bank.
It was at the same bank. The one lady, it was her safe deposit box, and her husband was listed on there as a
They were co-owners and they still wouldn't let them. It was Ohio Savings, by the way.
Yeah, so she was the owner and he was listed on there as he was able to get into it. She went in and said, my husband died, I need to get my safe deposit box, and they said no. And she said, but it's mine, and they said, we don't care.
You had to get a court
You
order.
have to get a court order to get into it. Same with the second lady. They were co-owners and they wouldn't let her in. So if you have a safe deposit box, close it. No, I'm just kidding. If you have a safe deposit box, go to the bank and say to them, if I die, can my spouse get into the safe deposit box, or my kid, or whoever it is? And if they say yes, say, okay, please give that to me in writing. So that you know for sure that if you die, that person can get into the safe deposit box. Or, and you didn't hear this from me, when they go in there, don't tell them that you're dead.
Exactly. Just keep that to
Just keep
yourself.
that to yourself. Keep it in your back pocket, they don't know, the little means. But as attorneys, we can't tell you to make a misrepresentation, however, that would probably work too, but.
It's not misrepresentation, it's extra information that they don't really need to hear because it's not relevant to why you're getting into the box. But you don't need a safety deposit box. If you do your yellow sheet, you can say, here's where all my stuff is. It's the yellow sheet though, it's got a lot of, pretty personal information. So we always tell people, you want to put it someplace safe. That is not your underwear drawer. Because if someone breaks into your house, that is the first place that crooks all look, because they know people are fussy about their underwear drawer, right? We would never go in anyone's underwear drawer. They go right to your underwear drawer and rifle through it. So, and don't put it in a book called Treasure Island, I want to sell, but there's a lot of places you can hide. All my stuff is in a cube, in a spare bedroom, covered with a pillow. So, I mean, I'm gonna have to move it now because But you want to think about where you want to put it, and then you let them know this is where it is if you need it. But you don't want someone sneaking in and getting all your passwords.
Yeah,
Can
I
you
always tell
file
people.
it with you guys also? Can't you file your will?
You can file the will with us. But all this other information, I think for $25, we will keep your will forever. The state of Ohio at this point says we will keep your will forever. So we have wills, beautiful little spidery handprint wills on tiny little, very thin pieces of paper from the 1800s.
Wow.
Yeah, some of them are beautiful, but we have to keep it forever.
So can you make, like an investment account, can you make it payable on death to more than one entity? Like,
Yes.
let's say I'm gonna give some to Elena and I'm gonna give some to Bath Community Fund. You can list more than one?
Yes, I think pretty much every investment company and bank lets you name more than one beneficiary.
And can
And-
you then designate like, 60% of
Yes.
this?
Yeah.
Okay.
Most of them can. At this point, I think most probably are able to do that. Back when I first started practicing, some were a little more strict and stringent on who you could name and percentages. If you name two, they said it's automatic 50-50, but now I think pretty much everybody
can
lets you say the
designate.
percentages.
Okay.
And the reason we don't have any issue with beneficiary or payable on death accounts is it's basically cash. So no one's gonna fight about it. It's not like who's gonna mow the lawn at the house that the seven of
Right.
us just inherited. Or, who's gonna wash the windows at that house? It's like, okay, do you want to keep the investments and transfer the stock, or do you want the cash? How do you want to do it? The brokerage firm would be happy to do that one thing, Kim Miller.
I'd be happy to do that. We do that all the time.
Yeah.
Oh, darn it, I always ask before I start making fun of banks, does anybody here work at a bank? I should have asked that.
Ohio savings that you need to take that.
Man, that is not Ohio savings.
Yeah, it's the same thing. It is a weird policy when the owner of a safety deposit, what do you think about that? Shouldn't they be able to get into it?
Is that standard for all banks?
What's that?
Is that standard for all
I,
banks?
the only time we've heard of it is that one particular bank.
So most, as with the law, there's usually all kinds of restrictions that the government places, and they could be liable for all kinds of issues, which I don't know, because I'm not on the law side, but believe me, even working for the bank, the hoops they make us jump
Yeah.
through, but usually the intent is to protect. But I did have two questions. In line with Karen's question regarding contesting, I'm familiar with inter rorem clauses.
Inter rerum, yeah.
Inter rerum clause. Is that something you?
Oh, it's so fascinating. They're starting to show up all the time now. So in terrarum sounds like terror, because it is. In terrarum means that if you contest, if the clause is written in and you say, I disagree with this, Steve took advantage of her, and I'm only getting 10,000 and he's getting 1 million. If you contest it and the clause says, if anyone contests this, they inherit nothing, those are upheld repeatedly. There is no way around them. They are very interesting. And if you have one, you really need to revisit your will or your trust regularly to make sure that everything is what you want. Because if somebody comes in and says, Dad told me that, I was going to get the house in Florida, and now you're not giving it to me and you're saying you inherited, making that claim, even if Dad did tell you that but never changed it, you are out of everything. So it's a very, very interesting clause. And I think a lot of lawyers went to the same seminar and learned about this because they just started popping up, but they have been completely upheld. You speak from the grave. That's what all these documents are. Are you telling us when you can't speak what you want? Did you have another question?
Well, I was just, again, in line with banks, since they're terrible and everything. From a, you talked about, Jimmy that was married twice and that, what if that's your only son? You know, if you wouldn't recommend a bank, who would you recommend to be a trustee? Is that it's gonna follow the law and do all the, I mean, because it is a big job to be a trustee, something I personally.
If you have boku bucks, I mean, really lots and lots of money, there's nothing wrong with using a bank. I think you do need to make careful the bank is not gonna keep the trust and keep it in trust for people who really do not need a trust. Which is something that you have to decide for yourselves. But they are very good at managing extremely large trusts. We have had people come in who have 17 different trusts because they've owned 17 different rental properties. And they've named all the children on 17 different trusts. That would be, it'd be much better to consolidate some of that into one trust and let an independent person handle it. But lawyers act as trustees. It can be a friend who acts as a trustee. It does not have to be a family member. If you have a child that you're worried about, like whom he described, you may want a spendthrift trust. You could protect it from the third wife that way. Or, whatever happens, he gets drunk into a motorcycle accident and hurt somebody badly. So there are times, we're not really down on trust. We just want you to be very careful about what it is your intentions are and make sure you express them. And picking the trustee, pick someone, if it's $10 million, we've got trust $30-40 million that come through our court. So if you're talking about that kind of money, an independent trustee is not a bad idea, which is a paid lawyer, bank, accountant, someone who really knows how to be a professional trustee, because there are a lot of rules connected to what you're supposed to do with trusts. If you have a smaller trust, your family could probably handle it, particularly if they're sophisticated in investing on their own. Yes, sir.
Isn't trust sort of meant to protect your assets a little bit more than just a will,
What do you mean by that?
though? I would say that being sued, I don't know whether they could come in and
Now that's a liability trust.
yeah.
So Steve's gonna tell you more about that. There are reasons so a lot of lawyers put their house in a trust and put other things in a trust so that if something happens, their family is protected. But go ahead, because you know way more about that than I do.
That pretty much sums it up. It's a trust that you can draft now and you can transfer an asset in there and it shelters that asset from creditors' claims. It's relatively new in Ohio. Probably what, 10 years ago or something?
It's not been long.
Maybe not even that long, but it's another tool that you can use to shield from creditors, but that is a specific kind of trust and there are a lot of requirements.
Called a liability trust.
Well, that's what we call it because it describes what you're trying to do, which is to protect your assets from liability. A lot of professional people do that. People who think they might be sued, doctors certainly have a lot of them. Other times they just put everything assets in the name of the spouse, which is ever so interesting if there's a divorce, because now it's all theirs and you are not there. You are just the guy who made the money. So
It's basically like an irrevocable trust.
Yeah, it is.
So with those assets, you have to put them into the trust. You have to have somebody else named as the trustee. So somebody else is in charge of them. And it's basically, you have to cut all ties to that asset. You personally, in order to shelter it from your creditors.
All right.
they're kind of dangerous. So if you're thinking of doing that, you really do need to talk to someone who is a sophisticated trust attorney.
Yes.
And there are differences between probate lawyers who can do regular little things and people who specialize in trusts. And most of the big firms have trust specialists, and then you would want to talk to and I'm sure the banks do too. If you have a bank, financial advisors can advise you, but trusts are very finicky creatures. You cannot do it on Zoom. We get calls and questions about it. It's like, well, Zoom has, and it's like, don't do that. Really, don't do your will on Zoom.
Legal Zoom.
Yeah, bad. They're all bad. They're very hard to understand too.
I have
Yes.
another question too. As far as safety deposit boxes, recently somebody told me that if you have a spouse that dies, the government comes in and audits the box before you can you can take it. Is that true or not?
So they used to in Ohio, when there was a state death tax.
All right.
Since there's not anymore, that doesn't happen.
What
And there was
about
a safe deposit audit? It was actually somebody from the fiscal office would go with you when you open the box and audit what was in there to see if you would owe a state death tax, but
So
now
that's
that
state
doesn't
by
happen.
state. State by
State
That's
by
state by
state.
state for sure, yeah.
How many people own land in Florida, by the way? Anybody? A couple land in Florida. So Florida is very interesting. I'm not gonna pretend I know Florida law. I just know that if those are properties you may want to think about putting into a trust, because then it can all be handled in Ohio if your family's in Ohio. They have a lot of rules about property transfers down there. I don't know them. I just know that I've had friends whose family has, somebody's passed and left a house, and it's very complicated to rent them or to sell them. So you may want to talk to your lawyer about putting your out-of-state property, not necessarily Florida, wherever it is, you may want to talk about putting that into a trust to simplify things. I know that at the Ohio Savings Story, the bank did not allow the two widows to go in and just open the account, open the box. They stood there to see what was in the box. And I don't know what they thought, bear bonds, I mean, her cocaine stash. No idea. But normally people put jewelry and important papers in there, so.
I have a funny trust story. About a year and a half ago, a friend reached out to me. She had 2 senior dogs whose people had died. She asked if we'd take the dogs, so of course we'll take the dogs. 6 months later, I get a call, there's a trust for the dogs.
Yeah.
And Jed, one of the dogs, just had $4,600 worth of surgery. I sent the bill to the attorney and he sent me a check.
Wow.
That's trust, do everything you want to do after you're dead. There's actually a dog in New York City that's a multimillionaire. Really, yeah, people carry this dog and he lives in the same house that his owner lived in, some very large. He can run through the rooms, I guess, be wherever he wants to.
I'm gonna have my dog buried with me.
All right.
Do you know? Let's talk about that. Seriously, let me talk about that, because pre-planning your funeral is another gift to your family. And you can make it's again, everything that you want your dog with you, you want your car with you, whatever you want, you want to be set afloat on a boat and burned, there's probably a place where you could do that. But you really can do that now, and you pay for it now, and they don't even have to think. They just don't have to think. With my dad, we knew exactly what he wanted. He had laid everything out with Hummel. We just had to go down and tell him this had happened. They came and we called them. They came and got the body and took care of it. My mother donated her body to the medical school. So in another year, there'll be a ceremony for her. But my dad had 2 metal knees and a titanium hip, and they recycle it. Get cremated. Because I said, can we take this someplace and have it recycled? They go, no, we do that. We just collect them all and then we recycle them. Titanium is I don't know, it's got some value, I guess, for a hip. He went to good use. He got put to good use. Did you have a question? Yeah.
The documentary originally first spoke about, do you suggest that you give them to all the healthcare providers?
You should. So your doctor should have them if you have a preferred hospital. I'm a Cleveland Clinic person, so I've taken it to the Cleveland Clinic. They have the advanced directives and my durable power of attorney.
So then as they change, you have to go back to each place.
Yes, I mean, honestly, there's no magic to an original with those documents. So you can make as many copies as you want. And I mean, it's good to give the original, if there is one, to your person who's going to make the decisions for you. But they just scan them. Sometimes they just scan them and give them back to you. They put them into their system so they know what you want. And to me, having been through this with both my parents, my dad had ALS and he stopped eating when he couldn't feed himself. So we went through that. It was, I gotta tell you something, he was an amazing old man. They started giving him the morphine. My mom was a nurse, so she'd give him the morphine. My sister's a doctor, so she was there to help him with all that. It was great. He came to the table, just didn't eat or drink anything, had lively conversations, kept telling us what to do. And then he was put to bed. He couldn't get out of bed anymore after a while. And we would sit there and talk to him. And then, it's almost a gift. He began to be delusional. Unfortunately, one of his delusions was that he had been elected president of the United States.
I know somebody else.
Finally made it.
And my brother, he wasn't even in politics. He was a metals guy. My brother was sitting there with me. He goes, well, so Dad, were you elected by the popular vote or the electoral college vote? My dad sits up and he goes, I'll give her. So, it sounds like it's really something sad. It wasn't, I mean, we knew it was gonna happen, but it was such a lovely experience to be with him. At one point he thought he was in Buffalo. He said, I'm in Buffalo on a sales call, but that picture looks just like the picture in my bedroom. Isn't that amazing? It is amazing, Kat. So it wasn't awful. I mean, it was still sad, but at the same time, he still was who he was. It's just like my mother was who she was, so.
With the, you were asking about the healthcare power of attorney and living wills, for example. Sometimes you'll go into the hospital for surgery, sometimes unexpectedly, and they say, do you have a living will? If not, here, sign this one. If you sign that one and name people there, the one that you signed most recently is the controlling document. So if you have one at home, and then you sign a new one at the hospital that names different people, that's the controlling document. So just be aware of that, because I know that is something in the hospitals that happens. You're here, hey, you don't have them here, sign these ones and name people. So just so you know, that is something that.
That's true with all your documents. The most recent one controls, which is why sometimes we get the lawsuits. And then we have many cases where the caregiver suddenly is getting everything. So that's the last one controls. That's why we get the lawsuit. Sometimes, yeah, that's a will contest. Yeah, we had one where the guy, he'd been in prison a bunch of times, and there were 7 kids there too. And the father had written, for reasons best known to my son, he gets $1. So he recognized his heirs. That's one of the issues. You recognize your heirs, your natural, the natural heirs of your bounty is what it's called. But he sued, and he didn't get very far but the problem was because he said for reasons known to him, he goes, I don't know any reasons. I don't know why he would have done this. So he bailed him out all these times, bought him a car, etc. So if you're going to do that, you want to tell us the reason. I mean, really, say, Frankie, I've supported him through this, that, and the other thing, and I've given him his, inheritance ahead of time, and so he gets $1. Yeah.
I have a friend whose father died. I guess there's a sizable, and things went to probate. And there's a sizable tax refund coming from the IRS.
Right.
And they're still waiting for it. So there's a probate court, just case that stays open, I guess that's.
Until, and we have people that wait sometimes 18 months.
Well, he's already done that.
Yeah.
Yeah.
It's not right now.
We're waiting for all the new hires that have been, they've given him money for the new hires to show up, and we're hoping that will speed things up for people.
We have a lot of estates that are open just because of that. Yeah,
tax
we want them to hurry too.
Yeah.
Yeah.
One other quick question about the exclusions that you might have in a trust or will. Is it valuable if you had a physician state you're mentally aware at the time that you made those decisions?
Well, there's an interesting process, which I only found out about a couple of years ago from a woman at St. Ed's who had dramatically changed her wills, her estate plan. The University of Akron was the primary beneficiary, but after several years at St. Ed's, she wanted to leave money to her caregivers. So she filed a lawsuit in court for me to declare that she was competent, which I did. I mean, she was actually a hoot, but the University of Akron contested it because they said, no, we have a memorandum of understanding. We're supposed to get this, and you can do it with the Akron Community Foundation. You have Bath Community Foundation. They say, well, he told us we were going to get, $700 million, and now look, he's giving it to his caregiver. But if you're competent, if you're worried about something like that, you can come to court. But that's why we have two witnesses. Two witnesses who are not named have to sign it. So if there's a contest, we bring in, Lucille and James, and they say, we signed these, we live next door to him, we've known him. He knew that was his last will. He knew who his natural heirs were. We don't know what was in the will, but we know that he was absolutely competent on the day that he signed it. So that's really why we ask that there be 2 witnesses names required. You can have as many as you want. Some people have 2 witnesses and a notary, but they would be called to court, as would the lawyer who drafted it, potentially, to say, no, we talked about everything. He knew exactly what he was doing. Is there another question for you? No? Well, that's the free legal advice for the night. Any other questions? Thank you very much.
Friends, thanks for coming, and we look forward to seeing you in our 10th anniversary year. We're at $1.1 million in the Bath Community Fund, and we're looking to keep that growing so we can help more nonprofits and do more programs like this. help yourself to cookies and candy. We're folks are still here, so you got personal questions?
We have extra yellow sheet if anybody needs extras.
Can I make a copy?
Yeah. This.